Good morning. I'm Dan Esty, professor at Yale in both the Environment School and the Law School, and it's a great pleasure to welcome you to our session this morning, part of Yale University's Planetary Solutions Program for Climate Week New York. And this is a campus-wide initiative really designed to help frame some of the issues that Yale researchers are working on and Yale-affiliated friends are working on as part of the push to deliver solutions for humanity, which is a major theme of the university. And we see climate change as a critical part of that conversation. Today, we are going to dig in, this morning at least, into the role of international institutions in terms of their climate change obligations. And I've got a wonderful panel of 3 speakers who will start that conversation, but we will turn as quickly as we can to a back and forth with all of you, and eager to have you offer a comment or a pointed question that we can put to our panel and kind of dig deeper into some of these critical issues. So with that, I'm going to jump right in and say a little bit of background on this topic. And I say this as someone who's been thinking about the response to climate change for now more than 30 years, going back to my own work as a part of the US government team that negotiated the original 1992 Framework Convention on Climate Change. So I like to joke that I've been thinking about this since COP0. And as we look at COP30 coming up, I think there is a fair bit of worry that the program that's been carefully structured now over 3 decades is not moving forward. And some would say not at all forward. Others would say not moving forward fast enough. So the frame of our discussion broadly is, are there new and different and better points of policy leverage that might actually drive the global community toward a serious response to climate change? And each of our 3 panelists will give you some thoughts on ideas they've been working on that question, and each brings a slightly different perspective. And I will tell you, I've got a 4th perspective on that. And all of this is, by the way, being discussed at perhaps a particularly difficult week in New York. As some of you know, across town on the east side at the UN, there was meant to be something of a celebration of 80 years of this important international organization, having come into existence in the wake of the tragic Second World War, and really reflecting a belief based on a very difficult first half of the 20th century that we needed as a global community some kind of structure of rules and obligations, of a framework of international law, which we will talk some about, and we needed institutions to help hold people to those commitments. And that is our specific topic today. What are the obligations of international institutions? How does one translate national commitments into the work plans of the international organizations that are meant to bring the global community together? So that's the starting point for our conversation. And I'm going to introduce first Camila. Camila Bustos is an assistant professor at the Haub School of Law at Pace University. And she served at a number of other places as a professor as well. And she's particularly interested in human rights, but also more broadly, international law obligations and what that means for countries. And we're going to have her speak in just a moment. Jason Weiner runs something called the Bank Climate Advocates, and BCA is an organization he founded and is really focused on asking how international financial institutions, the World Bank, but other parts of that IFI community, as it's sometimes called, how they should respond to climate change. What are the obligations of international financial institutions to bring a climate change lens to how they do their work? And we'll have Jason dig into that in a moment. Bain Kerr is our 3rd speaker, and he is particularly focused and has done significant research on decarbonization of the shipping industry. And I'm going to ask him to speak, again, in 3rd place here, on both the obligation of companies in the shipping arena, fundamental in some significant ways to the decarbonization of the global economy more broadly, but also the International Maritime Organization that I won't put words in Bain's mouth, but I would say started slowly on the climate change agenda, but has begun to gather momentum. And we'll let him comment on whether that's going far enough, fast enough, and if not, what might be done. But with that, Camila, I wonder if you could just say a few more words about your perspective on these issues and then dive in on this question of what are the obligations of international, of states with regard to climate change. Perhaps even commenting on the International Court of Justice's advisory opinion in July that sharpened that discussion and gave some quite concrete pictures of what obligations look like, and not only for countries, but for companies perhaps. And this is what I want to push you on, how does all that translate into obligations for international organizations?
Thank you so much, Dan. Easy questions to start the panel with. Good morning, everybody. It's a pleasure to be here. I teach at Pace. I'm an assistant professor of law, and my research focuses at the intersection of climate and human rights. And the past year, I've been really focusing on climate litigation and how is it that sort of the recent developments both across jurisdictions but also through regional and international guidance of the International Court of Justice or the Inter-American Court of Human Rights. What does that do? How do we ground those obligations and do we have time to even do that? So broadly, I'll be speaking mostly about the ICJ but also a bit about the Inter-American Court of Human Rights. Just for those non-lawyers in the room, like the ICJ, International Court of Justice, we're talking about sort of the world's court, the highest court of the UN system. Its advisory opinion is not binding in the way that it would be if this was a case between two states. That would be a contentious proceeding, but it is authoritative, right? It's persuasive and it's given a lot of weight and legitimacy because of its role. The Inter-American Court is the court within the regional Inter-American system that has a commission and a court. And again, it's advisory, so it's not binding in the same way, but it will be binding when applied in future cases, contentious cases. So just some legal primer out of the way. And so that has been emerging in a context of increased climate litigation against governments, subnational governments, private sector, and some international organizations, although I think that is the next wave of climate litigation. We were talking with some of the audience here today earlier about that. I will say two things about the ICJ opinion. It's a clear articulation of what customary international law is, which means even if you didn't sign a particular treaty, right, there are these sort of binding norms that you have to follow, right? And those are really broadly two. The duty of no harm, right? So the duty that now states have to prevent any foreseeable climate or environmental damage, that has been clearly articulated. And the second one is the duty to cooperate, and not just financially, but in terms of actually leveraging climate ambition. So again, the opinion has many, many pages, and we can get into the technical arguments if people are interested, but I think this is the first time we have such clear guidance from an international court on what states' obligations are in the context of the climate crisis.
Thank you very much. That's very helpful. I want to come back to some elements of that and help you, get you to help us understand maybe in more depth and detail what that looks like in practice. But let's turn now to the shipping sector. And Bain, I'm interested in both the research you've done on how the sector might decarbonize, but also how you think various actors within the sector, both companies and international organizations, particularly the IMO, what your sense of those obligations are and whether people are taking them seriously.
Sure. So thank you so much, Dan, for that introduction, and thank you to the Yale Planetary Solutions for having me here today. It's great to see such a big turnout for what I think is a really important topic and one that hasn't gotten enough attention, which is what role international institutions can play in mitigating climate change. So the IMO is a specialized agency of the UN, which was founded post-World War II, and its purpose was to develop globally uniform rules to enable the growth of the shipping sector. And by that metric, it's been very successful. The shipping sector has grown manyfold since then and is considered to be a highly integrated backbone of world trade. So around the time that the world community, the international community, began thinking about how to tackle climate change in the late 1980s and early 1990s, and Dan, correct me if I get certain aspects of this wrong,
We clearly have said something wrong, and the authorities are shutting us down. There we go. The light is back on. Thank you, Bain, for bringing the light back.
So there was a bit of there was a long discussion about whether emissions from the shipping sector should be handled by the IMO, which has been regulating shipping for decades, or whether it should be handled through the UNFCCC process. And this was complicated by the fact that emissions from vessels which go between two different countries are not easily assigned. So a ship that goes from California to Vietnam, should its emissions be responsible, should be allocated, responsibility for those emissions allocated to Vietnam or to the United States. Eventually, it was decided that the IMO would indeed take responsibility for mitigating emissions from the sector. And indeed, it was took a very long time, was off to a slow start, but recently there's been some really exciting developments. The IMO in 2023 resolved that it would reduce shipping's emissions to net zero by 2050. And just in April, it adopted preliminarily a net zero framework, which is a really complicated set of regulations, really amendments, mandatory regulations, amendments to MARPOL Annex 6, which will require the sector to decarbonize its fuel that it uses, and this will be enforced through a two-tiered pricing mechanism. And the pricing mechanism will both ensure that the very dirtiest ships have to pay for their pollution, and it will also incentivize the uptake of low and zero carbon shipping technologies. And it will result in significant revenue for the IMO that the IMO will manage and then distribute back into the shipping industry. So this raises all kinds of interesting questions. Also interesting is some of the political intrigue that's going on around the adoption of the IMO net zero framework. The United States has come out strongly against it. It abstained in April from the preliminary vote. The final vote is scheduled for October. The US has issued threats of tariffs and various retaliation against countries that support it. However, the framework is broadly supported by the shipping industry, by states all over the world. In fact, it was supported by almost all states. Only, I think, 16 states at the IMO opposed it. So more to come soon from the IMO, but it looks for now like shipping might actually be a leader in terms of global mitigation.
Wonderful, thank you. There's, again, more to dig into. Jason, let's talk a little bit about bank climate advocates. What was your theory of change in launching this organization? And what's your sense of the legal obligation of international financial institutions, beginning with the World Bank, but I guess including other multilateral development banks? So tell us a little bit about how you see this as a point of leverage for climate change action.
Sure. Thanks, Dan, and thanks to Yale Planetary Solutions for hosting this event and having us here. So I'm Jason Weiner, the Executive Director and Legal Director and Co-founder of Bank Climate Advocates, which is a nonprofit organization. And what we do is we're trying to reform and align international financial institutions like the World Bank with their climate change obligations under international law. And so we take an approach where we're using legal advocacy and legal action to achieve that. And up until the ICJ opinion, and hopefully it changes, these banks like the World Bank Group, Asian Development Bank, themselves are saying we don't have any obligations under international law. And then their member states essentially aren't ensuring that the banks are adhering to them. So what that looks like is these banks, they have, on the policy side, they have a sustainability framework, these Paris methodologies, energy policies. And essentially in these policies, they aren't taking any measures really to align themselves with the stringent and clear due diligence obligations that the ICJ just set forth. So essentially the ICJ set forth a stringent standard of high diligence when states act to regulate private entities and when they're acting at public institutions like the World Bank. That requires, I think I would categorize it in two ways. One is there's a stringent presumption against financing of fossil fuels. And the second element of due diligence is essentially that, that I think applies to these banks in their decision making before that when they're approving policies that determine what types of investments would they make and that condition investments to make them aligned with climate obligations. This stringent due diligence requires that these banks use best available methods and science to make sure that before they invest in a project, that the GHG emissions from each investments are fully quantified, that they do a rigorous alternatives analysis. If an energy project is examined, it looks at the economic and technical feasibility of whether renewables are possible instead of maybe a contemplated fossil fuel project. And then this diligence requires the banks to ensure that the projects avoid, as far as possible, GHG emissions. So between these Paris methodologies, the environmental and social sustainability frameworks, these exclusion lists, and the energy policies, they're all falling well short. And we hope that will change with the ICJ opinion. They're falling short primarily because the banks and the Paris methodologies, for instance, like the Asian Development Bank and the World Bank Group, they basically allow the bank to defer to a country's NDCs where a project is located to determine if the project is Paris aligned. As we all know, the current NDCs by most countries in the global south is where these development banks fund projects, don't add up to 1.5 degrees. So that's problematic. None of the policies the banks have in place have requirements to use best available science and best available methodology to reduce and eliminate and find alternatives to high emitting GHG projects. So they're falling short in that regard too. And then the exclusion lists, they still allow projects like LNG, and without those best available methods and standards in place in these policies that the banks are required to go through, it turns out to be very problematic for GHG emissions. So I think that's a good intro to all this.
Great, thank you very much. Let's dig a little deeper. So Camille, I'm going to start with you. You've laid out why and how this ICJ opinion, but more broadly the structure of international law that's emerging, creates obligations. What is your thought about what the world community should do when countries disregard those obligations? And I'm afraid we saw an example of at least one big country signaling its broad-based intention to disregard any climate change obligations in a presentation to the UN 2 days ago. Not to name names, but what's the response and who should respond?
So thanks for this question. I mean, I think this is on everyone's mind because we're talking about the climate change obligations, but we're really facing like a crisis in international law and international institutions and states, member states really losing their ability. Like the system Dan referred to, right, post-World War II was a system that centers states. And that's what our international legal frameworks do. They center states, they impose responsibilities. And globalization and everything else in the last decades, right, have really, I think, challenged that. And so we're really facing a broader crisis of international law, not just international climate or environmental law. So I don't think I can offer a comprehensive solution to that problem, right? But I will say that regarding the climate regime, I mean, you heard the numbers, right? The United States, Saudi Arabia, they continue to be at the margins, right, of what the international community wants and is doing. I don't want to undermine how important this means for the sort of legitimacy of the process itself. But I mean, Dan, you said it yourself, right? The UNFCCC process, the UN climate negotiations have been facing so much scrutiny, even from people who worked within them for years, right? And now there's this kind of question of, should we go to COP? Should we have COPs, right? The next one's coming out in Brazil. I will say, though, that I get a lot of hope from some of the language in the ICJ opinion. And if you let me, I want to read 2 sentences because I actually think the ICJ opinion also named the elephant in the room, which is the fossil fuel industry. It's not the only one, right? There's lots of other industries. But building on sort of Jason's comments, right? The ICJ said, failure of a state to take appropriate action to protect the climate system from emissions, including through fossil fuel production, fossil fuel consumption, granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies may constitute an internationally wrongful act, which is attributable to that state. And if you've been following any sort of climate international process, the naming fossil fuels or a potential phase out was just unthinkable, right? It was kind of just not something that we thought we could get in the actual text. So I just want to sort of say this is a product of lots of organizing and social movements and really smart lawyering and advocacy in front of the court. So I think that's definitely one of the actors that we need to be thinking about. A lot of my work actually looks at how lawyers enable the fossil fuel industry to act and operate through lobbying, litigation, and transactional work. If you're interested, talk to me after the panel. But I think we need to start sort of naming names. And at the same time, the paradox here is that we need robust, bold action. And if we have cases or litigation that are asking for too much, we might get courts that are really hesitant, right, to deliver on sort of really ambitious remedies. And so the paradox of climate justice that we're facing with all of these questions regarding states and international organizations is we need them to act now, and we want litigation and negotiations and other processes that are going to push for that ambition, and yet that might backlash, right? And so it's this kind of really, I think, critical question about what case, what facts, what international institution that we can talk a little more about. But that's really where the action of grounding these abstract principles and sort of advisory opinions will be at.
So let me push this a little further, and Bain, I'll let you start, although any of the three panelists may have a view on this. So what happens when parties, countries, to some of these international agreements and international institutions take inconsistent positions? So we've got a lot of countries that have signed on to the climate change agreement, 190, I think, last I saw. And yet when they go, and the case that I've been looking at is the World Trade Organization. And my own hypothesis is, as a point of leverage, trade could be very powerful, because the World Trade Organization was set up in 1995, not, as some people think, to open markets or produce economic efficiency, but with an overarching mission of producing sustainable development. That's in the first paragraph of the Marrakesh Agreement that sets up the World Trade Organization. And yet countries that have signed on to the climate change agreement show up in Geneva at the WTO and poo-poo the need to focus on the fossil fuel industry. In fact, the trade system has decided it does not want to address fossil fuels, and that's been kind of excluded from the agenda. And likewise, at the IMO, some of the same countries that have signed up to climate change action go to the IMO and say, no, we shouldn't have the IMO align with this world community commitment to deep decarbonization. So what do we do? And I'll let Jason come in afterwards. So Bain, you start, and we'll let Jason follow.
Well, with the IMO, it's an interesting, maybe unusual outlier in terms of international institutions, in that it has majoritarian voting. And that majoritarian voting is driven by the largest flag states. And the largest flag states in the world, some of them happen to be small island developing states and least developed countries. So the IMO is actually able to adopt mandatory measures which apply globally to the entire shipping sector on the basis of a majority vote. So this is kind of an interesting corner of international law, where if there is a majority of countries, especially certain countries that you might not expect to have so much authority, they can push the agenda forward. And that's what we're seeing happen.
So just a parenthetical, because that is a very interesting difference from the World Trade Organization, where some of you will know there is a very, very strict view of consensus-based decision-making, such that any country, the smallest, or any single country of any sort, can block the agenda from going forward. So that's, I would argue, crippling to the World Trade Organization's ability to move any of this forward. But Jason, what do you think? Dig in here.
Well, in terms of finance institutions, there is a consensus-type voting. So at the World Bank Group, for instance, the countries with the largest capital contributions have the most shares, and in terms of most votes. And countries like the United States, Germany, France, for instance, and the UK, all cast their own, they have their own executive directors that cast their own votes. And then other countries, some Global South countries and other European countries and Canada, for instance, are all in these consensus voting blocks. But, with the ICJ opinion, it's states' obligations, regardless if they're in a voting block or if they're voting on their own, clearly have customary duties under international law. And some have human rights treaties obligations, and all have law of the sea obligations, to align their votes on both individual investments and policies with their climate change obligations under international law. So we're hopeful with the clarity in law that judges are now aware of around the world, that if these banks, if advocacy doesn't work to align and diplomacy doesn't work for countries to align these investments and their policies with 1.5 and their climate change obligations, that litigation against various member states in their own countries by harmed citizens and affected communities could be a very effective tool. I will say that it's our understanding that groups like the World Bank Group, that if one country opposes, or there's not consensus, if one country votes to oppose a project, then the financial incentives for staff that have proposed the project and put together are taken away. So the bonuses are removed. So there is internal incentives as well within these banks.
To keep people
Right.
on board and working to establish a consensus.
That's right. Yeah.
So let me push all of you on one more point, and then we're going to go to the audience for questions. So do prepare a sharp, focused question to help drive the conversation. Why focus only on litigation against countries? Why not focus on litigation in climate advanced judicial structures, lawsuits against companies that are inconsistent? Camilla, I'm going to let you start because I think this is a line of, again, potential future leverage that might go with greater effect than for, I'll pick a country that's got a pretty good structure of climate change litigation, Colombia. So why not bring the case in Colombia, not against the United States, that's a tough one, but against ExxonMobil?
It's working? Yeah, okay. I like your thinking on all fronts about corporate accountability and using different jurisdictions to try to, again, ground these obligations. Because a lot of it is we don't know what this actually would look like in real cases with real facts, right, between parties. And I think litigation is one way there. I think we've seen, again, sort of this massive trend in the last 10 years of litigation against governments, right? But the private sector has been targeted. I don't think as much as governments because the obligations remain, I will say, less clear in their eyes, right? That's not true, right? There's so much international law guidance and obligations on private sector entities, multilateral banks as well, and international organizations. I think you can read Bain's thesis on this complicated question. That said, again, I think this is the next wave of climate litigation. I really think there's some legal wrinkles about jurisdiction and kind of where and standing and all those things that lawyers love to talk about. But I think ultimately it's a matter of continuing to try to bring these lawsuits and seeing what the ICJ, but also the Inter-American Court opinion, what those actually look like on the grounds. For example, Colombia obviously is bound by the ICJ opinion, but it's also a member of the Inter-American system and subject to the jurisdiction of the Inter-American Court. That court actually said so much more on the obligations of the private sector, on transparency, not greenwashing. I mean, I have a long list. I'm happy to send you, right? But there is a lot of specificity in terms of what the obligations are, not just to disclose, right, or account for greenhouse gas emissions, but actually to fulfill human rights obligations. And again, the states are supposed to oversee the private actors doing that. So it's this kind of multi-actor strategy. And I think we need all of it. It's really an ecosystem of advocates targeting different enablers. And for me, ultimately, this is about who's enabling the climate crisis, right? The banks are, the lawyers are, the states are, and we need to go after all of them through different strategies.
All right, either of you want to add a thought?
Yeah, I'll add a thought. I think we do need to go after all of them. One of the reasons why we go after public finance institutions, specifically multilateral development banks, is many climate scientists think that how the global South electrifies will largely shape whether the worst effects of climate change are avoided. And finance and the flow of money to projects in the global South, which is largely controlled by public finance institutions like multilateral development banks, plays an outsized role in that. I mean, true, maybe multilateral development banks, they have, for instance, immobilized in 2024 about $130 billion in climate finance. The IFC itself invests over $30 billion a year. The Asian developed banks at $20 billion a year, but they mobilize far more money than that, and they offer these things called guarantees, which is political risk insurance and conflict insurance that actually enables private capital to then go into the global South and invest with confidence. And their climate change obligations don't only apply at MDBs, multilateral development banks, to financing and equity investments. They also apply prior to guarantee decisions as well. So if we can get the public governments of the world, at MDBs in particular, to align with their climate change obligations, that really has a big impact and a trickle-down effect to private capital. Also notable, although a lot of groups, private banks have left the Equator Principles, so the Equator Principles are voluntary standards that banks have pledged to. Private banks like Wells Fargo or J.P. Morgan or Chase, they've all, not a bunch of them, a lot of them have left. I think over 120 now have adopted the IFC, International Finance Corporation's sustainability framework as their standards. And those have climate change protections. So what happens at public finance really has a trickle-down effect in many ways with private capital. Let's leave it there.
No, I like that And I'm now going to do something extremely annoying that professors sometimes do. But I wrote an article called Should Humanity Have Standing? In the Southern California Law Review. And here's my hypothesis for you. Why not assemble a series of groups, a coalition of groups that brings a set of lawsuits called Humanity Has Standing and sue in the 20 jurisdictions, and by the way, that article identifies where climate litigation has proceeded the farthest, sue in 20 different jurisdictions simultaneously on the theory that if you sue the biggest polluters, the oil companies might be a good start, in 20 jurisdictions simultaneously, and win, as I think you might, in a number of jurisdictions, sanctions, you could send a real shot across the bow and maybe even chase some of these companies out of performing in global markets because of the litigation exposure they would have at a start in 20 jurisdictions where you've brought the lawsuits, but beyond that over time. You want to launch this?
I just have, I guess, a question for you, but the rest of the panel too, which is litigation risk sufficient? Like, do you see litigation risk among other strategies as building that pressure? Because ultimately it's just about pressure, right?
No, it's about pressure.
I mean, writing obligations, but also there's some geopolitics behind it.
Of course. And by the way, not every bit of litigation is brought with a thought that you're going to win. Sometimes it's brought to simply say, shouldn't humanity have standing? Shouldn't what people care about be part of the conversation? And I guess my sense is, having looked at these 20 countries that are really pushing this litigation strategy forward, you would win some of those cases. And you might get a $1 trillion damages application by some of those countries on the theory that they have to set the standard and move forward. And I'm not sure you'd ever collect, but I'm pretty sure it would be an interesting start. And I suspect the lawyers in those companies would begin to say, gee, maybe we should pull out of certain markets. And that would begin to change how people think about the issues. All right, with that thought exercise on the table, I'm now ready to see if any of you have questions from the audience. There's microphones that we're going to run around to anyone who's got a question. Please do introduce yourself, and you can ask a question to the panel as a whole or to a particular speaker if you prefer. All right.
Hi, Paul Rink. I'm a professor at Seton Hall Law School, working in climate law. And this is a question that can go to the whole panel. You obviously work in very different areas. And Camila, in particular, you mentioned the ICJ advisory opinion that talks about different areas of the law that states have obligations under. And you also talked about different ways of holding these different organizations internationally accountable. I'm wondering if there's a particular litigation or arbitration or some other enforcement mechanism that you're excited about right now as an opportunity to use some of these tools and frameworks to hold either companies or states accountable for their climate obligations.
It's almost like I planted the question, but I didn't, I promise. Some of my work is actually looking at implementation of climate remedies. So there's a lot of literature on climate litigation to some of the trends that we were just talking about. I'm asking the question, great, we win, what happens after? What does this actually look like? And there's just not that literature on that yet. So I'm part of that emerging sort of group of scholars that are asking sort of these hard questions of how do we actually implement and collect and all those things. And now with the ICJ opinion and sort of its robust language on reparations and also the Inter-American Court and the question of what climate reparations may look like, I don't know, we have lots of articles and books and talks to have. I'm really interested in what's going to happen in the Swiss case. Some of you may have been following it. It was first introduced domestically. It was a case where older women were sort of alleging rights to their violations to their fundamental rights because of climate change. They lost at the domestic level, brought the case under the European Court of Human Rights because of the European Convention. Ended up winning, and now there's this back and forth between Switzerland, the court, the Council of Member States in Europe, and just this like kind of really robust ecosystem of Switzerland saying we are implementing, we have already implemented the decision. I'm again paraphrasing, it's much more complicated, right? But then the court saying, and the Council of State saying, no, you haven't. Like you haven't actually done the carbon budgeting that's necessary to fully implement the decision. And it could get super technical. But I think what happens there is gonna hopefully give, again, more robust foundation for future litigation and what carbon budgeting actually demands from states and potential international organizations.
And if I could pick up on the implementation theme that was just mentioned, there isn't a particular arbitration or case that I'm excited about, but the EU and the IMO both now have, well, IMO hopefully will have regulations in place. And so we'll be really interested to see how those are implemented. Will compliance deadlines be enforced? Will other actions be taken? Will they be relaxed? What's going to happen? And I'll also note that with the Klimasynorinninen case, the court specifically noted that there were embedded emissions of Switzerland accounted for, I think, 70% of its GHG emissions. So those are emissions, scope 3 emissions, that are within products that occur both from the production of the products but also their transportation. So Switzerland's implementation of its climate obligations could arguably have something to do with the shipping sector too.
And I will add to that, some of the biggest commodity traders are Swiss-based. And I heard in a panel yesterday, my fun fact for the week, that the biggest oil companies are no longer ExxonMobil or Saudi Aramco. It's the commodity traders, moving more oil, owning more oil. So that's another point of focus as you imagine this, should humanity have standing legal attack. Jason.
Nice, yeah, just that. And I think that one of the areas we're most excited about is looking at litigation in various countries against states when acting at MDBs that are failing to both adopt adequate policies and then implement the policies, the board-adopted policies they have in place. I'll give you two examples. One, the Asian Development Bank is currently updating its 2021 energy policy, and the policy has very, very limited fossil fuel exclusions. And during this process, the bank, and its member states, aren't requiring an assessment of the bank's climate change obligations and each member state's climate change obligations in reviewing the policy. So they're not even conducting an analysis of what the climate change obligations are of the states when voting to approve the policy and proposing amendments, nor the ADB itself. And at IFC, they have a very outdated environmental and social framework in which they're not even adhering to. So since what Bank Climate Advocates did, and IFC has a 2012 environmental and social policy that sets forth essentially the due diligence for GHG emissions, alternatives analysis, and mitigation. So we analyzed 350 projects from 2012 to the present and found across the board that IFC was systematically failing to ensure adherence before project financing of their GHG environmental assessment and mitigation requirements. And so we brought that to the IFC management. And granted, these policies are outdated and not even in line with their current climate change due diligence obligations. So we brought that to IFC management. They decided they didn't want to do anything. We actually got the internal dispute or internal accountability mechanism at the IFC to take up the case, to use their discretionary authority that's seldom used to examine whether our claims had merit. And they supported and substantiated all of our claims. So now we're in a phase, well, we have a very strong IFC independent accountability mechanism, its own accountability mechanism's opinion that substantiates IFC isn't even following the inadequate policies it has in place. And IFC management still isn't doing anything. So I think the next step is potentially looking at litigation if IFC can't get its act together, both in improving its policies to align with its climate change obligations and its upcoming performance standard review, and then implementing them.
All right, let's see if there's another question here in the third row. And then we'll go 2 rows back from there.
Thank you for the wonderful talk. My name is Adam Yu, and I'm with Macmillan Center, Yale University. And my question is, I'm wondering about the international law design and framework to support the capacity building to comply the regulation. Because the international law framework can help to induce a trickle-down effect, as you mentioned, for the not just for the finance, but also technology for developing country and then also like small island countries. So I'm wondering about the framework to help the capacity building to comply the regulations.
Any of you want to take up that question?
Well, I'll say that with regards to the shipping sector, that's a really critical question because the lower and zero carbon technologies that are going to be necessary to decarbonize the sector are new. That involves likely ammonia, methanol, biofuels, and there isn't necessary port infrastructure, and there hasn't been adequate training of seafarers in how to safely handle those products. So that's going to be a really critical part of the IMO's work over the coming 15 years. And it's important both to ensure that the decarbonization effort is successful and also that it is done in a way that respects human rights.
I will just add from the point of view of the trade system, there is a little sister to the World Trade Organization, which is the big trade international organization, and UN Trade and Development, which is the second one. There's another organization called the International Trade Center that's got several hundred people in Geneva, the main purpose of which is to help small and middle-sized enterprises in the global south become trade ready. So a lot of work on tariff classifications and how to post bonds. But the work that I've been doing with a team across the world under the banner of the Remaking Trade Project and the VLAR framework for a sustainable trade system that was produced by this group of 400 thought leaders argues for repurposing the International Trade Center into a sustainable trade center with the express idea that this could become a capacity building entity more broadly, and particularly helping those small and middle-sized enterprises meet the emerging sustainability standards and ensure that they're not kept out of markets by penalty tariffs of the kind the European Union's proposing, but rather coached in how to meet those standards and be able to enter the market, but with a clean production process and products that meet expectations of the marketplace. So I think there's an interesting set of changes and transformations coming to many of these international organizations as they try to fulfill the global community commitment to climate action. All right, in the very back row, in the very back corner, we've got a question, and I see several others right after that.
Thank you. Ray from Citibank. A question on the finance side. So who pays for the bill of this massive transition, right? So a term I heard repeatedly this week is that public-private blended finance. So I would probably be interested in listening to your, maybe Jason, your thoughts on that term, and what do you think of the role that international organizations can play to facilitate that conversation? Thank you.
Right. Yeah. Well, thank you. You know, I think that this is an example of why what happens in terms of policy and then implementation of policy at multilateral development banks and is so critical, right? I mean, first and foremost, as public financial institutions, and especially the global north, the countries, they have stringent standards of diligence, and if they're able to meet those standards, I think that the public-private finance could be a very effective tool. But one of the problems that we're seeing is that these banks, these multilateral development banks, that are supposed to be serving the people and helping affect communities in the global south, are catering too often to private interests, and which is, in our opinion, the reason why their climate change policies are so weak and not properly implemented at all.
All right. And we'll go to the second row and then to the first after that.
Thank you. Hi, my name is Luciana. I have a question that I want to build based on your mention on ammonia. Within the green ammonia and green hydrogen roadmaps policies around the world, I think there's hope for the development of such industries, particularly in the global south, but still most of the countries that want to pursue these roadmaps still face challenges related to the finance. And even once we settle those problems, I'm from the global south, that's why I speak in that sense, how can we ensure social justice in relation to the development of such industries? Because we still are facing problems related to extractive industries, but also mining industry, which are also critical for the energy transition. So when we think about the development of new technologies to a decarbonization path, how can we ensure proper finance for such projects, but at the same time, infrastructure and social justice?
Jason, you want to start on that? Yeah,
sure. I mean, development institutions like the World Bank Group, European Bank for Reconstruction and Development, all these multilateral development banks, their safeguards are outdated and they don't have high enough standards of due diligence. And the due diligence obligations, the human rights due diligence obligations to assess, the full environmental impacts of projects, to consult with affected communities, and then to avoid and mitigate these impacts. The requirements just aren't stringent enough in the environmental and social policies. So often we see these mining projects in the global south, and they're harming communities and quite devastating. So I think that there needs to be substantial reform at MDBs, not only in climate change, but in overall due diligence to ensure that there's a just transition and that the harms are avoided and minimized, to communities, and that responsible projects are pursued. Within the World Bank Group and many of these development banks, there are these accountability mechanisms that I touched on earlier, where affected communities can bring complaints and try to achieve redress. But the problem with those is that, those need reform as well. And we're starting to see a trend where if the accountability mechanism finds harms, there can be remedy. And there are remedy policies that are starting to be adopted, but they just don't have enough teeth. The problem with the accountability mechanism is that after the financing is made and the project is underway, the harms are already there to the communities. So I think that there needs to be a very big focus on what happens prior to project financing in terms of diligence and improvement of these policies. And hopefully some litigation if advocacy isn't enough and campaigning isn't enough to reform these policies and get banks and their shareholders to ensure that these development banks align with their due diligence and harm prevention obligations under international law.
Thank you.
Hey, I'm Ethan Thorpe. I'm from the Vanderbilt Private Climate Governance Lab. So we're talking about 1.5C, but as I think a lot of people in this room recognize, 1.5 is a long shot right now. We're probably looking at 2 or 2+. Given that, what do you see as the role of international organizations in proactively adapting to the new climate scenarios that communities are going to feel, 1, and 2, what's the role of international organizations in sort of legal gray areas? So I'm specifically thinking about climate migration, where we don't have any international agreements on what climate migration means, who is a climate migrant, what rights do they have, and how can international organizations help to fill those gaps such that people who are forced out of their homes are not trapped in sort of the milieu of climate disaster?
Bain, you want to start?
So I don't have answers to all those very good questions, but what I would say is that in general, and this is maybe optimistic, is that I think that there's a real need for sort of old-fashioned liberal internationalism in terms of how we think about the climate crisis, and that international organizations will have a huge role to play in addressing all of those issues, and they're the only entities that can address those issues. They're the only entities where states can come together to resolve differences, to agree on a path forward, and to find solutions. I think that there's a lot of international organizations. They have a huge diversity of membership. They have a huge diversity of mandates, and I think that I expect and hope that they'll all work on those issues.
Jason, you want to add something?
Yeah, I would just hope to see that international organizations and finance institutions focus less on profit and pool more resources in finding ways to compensate for loss and damage caused by the global north, and also for adaptation. And I think those are some challenges that need to be focused on. And I think that the global north countries, there's lots of measures and taxes that global north countries can, and subsidies, elimination of subsidies of fossil fuels, for instance, the global north countries can implement and then channel through MDBs potentially if their governance improves to help solve and remediate all these harms to the global south communities.
So I'll just give you 2 examples because I think your question's so rich, right? This is a domestic example of the US, but Vermont and New York have been among the first to create Superfund climate bills. And those are facing lots of litigation, but essentially for those who don't know, it's this idea that we're actually gonna tax the polluters and actually get that money to pay for adaptation. It's much more complicated, but that's essentially the idea. I think those initiatives are amazing. And that's something that's happening at the domestic level that doesn't require necessarily all of these international organizations to come in, right? Although they can totally be part of the picture. To your second question, I think there is this kind of conversation that's coming domestically and internationally that the member states and the organizations are talking about. So the example I'll give you is in Colombia, which we talked about, has some incredible jurisprudence in terms of climate and environment. On migration specifically, for a long time, there were advocates asking for climate migration to be recognized. Last year, the Constitutional Court finally issued a judgment saying climate migrants are displaced people who are subject to constitutional rights protections. And that has nothing to do with the Refugee Convention or what the UN Refugee Agency says or does. courts. Now, that's another point of leverage, right? But I do think there's incredible domestic action that's happening on a lot of these issues: finance, adaptation, migration. And again, I don't know, I'm kind of an optimist too. And I like to see this development as part of this broader network of accountability. And maybe we're getting kicked out now.
There we go, once again, over the line. All right, thank you, Camilla. It actually brings a question I'd like to put to all of you, which is the sense that the evolution in international law is, in some regards, quite powerful. And Camilla, you've given us not only the ICJ, but the Inter-American Court and some other examples. But these are advisory opinions. And so what happens when countries just ignore their legal obligations? And Jason, maybe you start, because some of this is being ignored at the international financial institutions.
Right. And time will tell whether the member states, when acting at these institutions and the international organizations themselves, actually listen and implement what the advisory opinions say. So I think this just highlights the need for litigation in states. And like I said earlier, I think one of the things that's really useful about this ICJ advisory opinion is that judges around the world, whether in the UK or Germany or France or Canada or Colombia, all the judges now are on notice. Exactly, it was a unanimous decision, right? So
including a U.S. judge.
Right. So the law is now crystallized. It's clear. So judges around the world know what the customary international law obligations are of each state, of each country. They know, have a better idea when countries are party to a treaty, exactly what's required in those instances too. So I think this just gives rise to litigation, lots of litigation opportunities to force states to adhere to their climate change obligations.
So you see judges around the world, justices of Supreme Courts even, being informed by the international law as establishing norms that they should reflect in their domestic judgments.
I do, yeah, in various countries.
Although I did note the United States was not on your list of countries you ticked off.
Right.
Bain, you want to add to that?
I agree with that, and I think that the turn we're seeing in international law is actually international law has been on its deathbed since it began. It's been a perennial question: are we witnessing the end of international law? And I don't think that we are. I think that it's going to be invigorated, and it's going to continue to be relevant. And it's within domestic judicial systems, as Jason alluded to, in other countries, it's more important than it is in the United States. So I think sometimes here in the United States, we kind of live in a bit of on an island, separated from the rest of the world. But I think that what we're going to see is that given how interconnected we are, given that we live in a globalized economy, what happens elsewhere is also going to affect what happens here.
Right. In shipping, it's really, what the United States wants to do in terms of its climate change obligations in shipping. It doesn't really matter as much, does it, in terms of the decarbonization of the shipping industry, or what's your opinion on that?
That's right. The U.S. is non-participation in the decarbonization of the shipping sector won't stop the sector from decarbonizing, because a ship that sails between New York and Rotterdam is still going to have to follow IMO rules, and it will follow IMO rules because that's how international law works. So the U.S. can't block it, and I think it's important for us to keep that kind of optimistic note in mind.
Camilla, anything to add?
That I think the question you're asking, Dan, is a question about the legitimacy of courts, right? And what happens when people don't follow what a court order says, which has also been happening in this country lately, for all the arguments about American exceptionalism. So again, I think there's here lots to learn about how other countries that have been in situations where courts maybe are not necessarily following the rule of law as closely as maybe traditionally this country has, right? Again, and this is a question about implementation, which I'm so excited about, because lawyers bring these fancy cases with really articulate and technical arguments, which is super important, right? No one needs a bad lawyer. We need to create really robust jurisprudence. But then what happens after? And that's not just the job of lawyers, right? That's the job of interdisciplinary teams and of advocates. You need to build pressure, right? Whether that's through litigation or other strategies. We have lots of amazing law in my country, in Colombia, right? But a lot of that has been only implemented after there's been enough pressure on governmental actors and defendants to actually implement the decision of the Constitutional Court. So again, challenges around global north, global south, but I think that this is an international dialogue that gives us lots of, I think, interesting comparative points and examples to move forward.
Great. A last question anywhere in the room or two? If not, I'll ask one myself. Please, right here, Alberto.
Alberto, I work at Elemental Impact, which invests in clean tech startups. So on this question of countries that are not compliant, do you see a path of countries using their economic force to enforce these international regulations in other places? So I'm thinking like the case of maritime regulations like fuel, EU maritime regulations forcing US, the shipping industry here to decarbonize, or like carbon border adjustment mechanisms.
Ben, you want to start?
Yeah, so I think that what we're seeing, at least from the European perspective, is that there's been a real frustration with the lack of global progress on climate in terms of the shipping sector, but elsewhere. And the EU has been monitoring what's going on at the IMO and also the ICAO, which is in charge of aviation, and steadily expanding the footprint of its own rules. So currently, the EU rules cover 50% of voyages to and from European ports. That may be expanded depending on what happens at the IMO. So there's a dynamic here where there's a bit of unilateralism is actually helping to spur multilateralism, and that indeed may encourage the uptake of new technologies.
Thank you. Any other questions, thoughts, comments? Please. You have the third row on the left and then the fourth row on the right.
Yeah, I'm Sari from Tokyo Waseda University, and my question is, when you see the Asian and South Asian areas, we can see the dilemma between economic efficiency and regulation. So, for example, Vietnam, Indonesia, those countries look like they prefer choosing GDP growth to choose following international regulations. So, when you consider international law, do experts have any subsidies or hooks to draw those countries to follow the rule, or do people force them to follow the rule after just like legislation? Yeah, that's my question. Thank you.
Well, sure. I mean, our position at Bank Climate Advocates is, global South countries have a right to develop. And what we push for, we won't oppose a fossil fuel project if it's the only source of economically or technically feasible technology to provide electrification to countries. But oftentimes that's not the case. Oftentimes there's economically and technically feasible alternatives to propose fossil fuel projects, especially since solar is so cheap in places where sun is readily available. And then even with other types of projects in terms of climate change mitigation, with these environmental and social frameworks, if they're aligned with the right due diligence standards, that will essentially just require, and the banks should subsidize this, proper diligence to assess alternatives that are economically and technically feasible to avoid and mitigate GHG emissions from all projects as far as economically and technically feasible, for communities in those countries. So the first step is getting that right study and diligence in place, and then conditioning the financing and guarantees upon that. And we think that needs to be done and should be done, and that would address a lot of those concerns and that tension that you raised.
And the VLAR framework on the trade system offers a perspective on this as well, and it is that there should not be development done on a non-sustainable basis, and that with the existential threat represented by climate change, there needs to be that taken as a starting point, and that the suggestion is the WTO should recast its rules around things like subsidies to make sustainable development the centerpiece of the structure, as was committed to in that 1995 Marrakesh Agreement. So take a last question here, and then we're going to have a moment for our panel to wrap up, and then at least some of them are able to stay and continue the conversation on a one-on-one basis.
Thank you so much. This has been fascinating. Yesterday afternoon, another panelist made an observation that countries vary widely in their capacity and their ability to do very detailed analysis of their own carbon budgets, et cetera. And given the focus of this conversation on cooperation and capacity building and support transnationally, I'm wondering whether there are any mechanisms in place to actually assist in developing those abilities where they may be lacking.
I mean, it's baffling to me at the World Bank Group at IFC. There's like over 150 environmental and social framework specialists, and it doesn't seem like any of them are properly trained in best available methods to assess Scope 1, 2, and 3 GHG emissions, and to conduct proper and fully supported alternatives analysis to avoid and reduce emissions as far as feasible. And this is a major point that we've raised at the IFC, and it continues to be a problem. Their Paris methodology assessments, they don't release them for public review. The World IBRD does, and there are 2 paragraphs, and they don't go into any detail. There's no supported analysis. A lot of the banks, like Asian development banks, they say, oh, we can't, Scope 3 emissions, it's hard to quantify. But in California, under the California Environmental Quality Act, practitioners are assessing fully Scope 3 emissions every day and releasing them prior to public decision-making and financing decisions and permitting for the public review and scrutiny. This should be done at these in global north countries and also at these financial institutions with greater resources. The level of diligence is high. It's very high when global north countries with a lot of financial resources, have these capabilities, and these banks and their states at the banks just are falling so far short.
Camilla.
Yeah, I'll just say briefly that I think this is an opportunity for bilateral agreements and to rethink climate finance a bit. I don't know, again, I'm thinking about Colombia and sort of Norway, Germany, and other European countries that have for years sort of given overseas assistance to stop deforestation. And that's really important, and we should. Land use change and deforestation are a massive source of emissions. At the same time, with how much of that money is actually going to building capacity, right? And I think it has to come from, starting from the bilateral angle, right, where like countries are like, we don't have the skills, we need this ability, we need support for this. And I think it has to shift a little away from the more traditional conservation too, because a lot of mitigation, climate finance is not building that capacity necessarily.
And Camila, just to add, when the World Bank Group or Asian Development Bank or European Bank for Reconstruction and Development is looking to finance a project in the Global South, if the company proposing a project or government doesn't have the in-house capacity, the due diligence then falls on the banks to ensure that capacity is provided in its financing. That's our position.
And that's actually a good best practice, is to say that if you're dealing with parties who don't have capacity, the big player in that chain of value should step in and provide the necessary backdrop for a thoughtful decision.
And that's the position we're taking at these banks.
Has the bank said that formally as a policy?
Well, yeah, their environmental and social safeguards require it. Their environmental and social safeguards at the IFC, it's the performance standards, and their overarching environmental and social policy require that the bank ensure that the due diligence requirements in those policies is adhered to. And that's where the bank's falling short. They get these environmental impact assessments that are some of them don't even have any quantification of Scope 1 emissions, or they emit a very apparent Scope 1 emissions. They don't have Scope 3 quantification. And then the bank's not filling in the gap, either with its own expertise or hiring consultants, to ensure that its duties are adhered to.
We are near time, and I just want to offer our panel a last minute each to say anything that you haven't had a chance to say or an observation about the flow of the conversation. Bain, I'm going to start with you.
Well, I think that it's interesting being on this panel and hearing how interconnected all of these issues are, and sort of how you can think about international climate obligations of states and how that flows into the decision making at international organizations, and how if shipping is going to be successfully decarbonized, it requires investment, landside investment from entities like the IFC in order to invest in ports and so forth. So I think that it's really important to sort of have attention on international organizations and what they're doing, and it's also important to understand how they relate and how they can work together.
Camilla.
If you're interested in what remedies or climate reparations broadly can look like, and again, I'm not necessarily saying just compensation, I'm talking very broadly about what a remedy can entail. There's some amazing language in the Inter-American Court opinion on even like compensating for like medical injuries related to climate illnesses, right? Like we're talking like all kinds of things. So that would be my plug for the Inter-American opinion.
Wonderful.
I would just say at international development banks, like, given that there's now the ILOS opinion, Inter-American Court opinion, and the ICJ opinion, that the next year is going to be very telling. And we sure hope to see a lot of movement and improvement, and drastic improvement at MDBs in terms of adhering to their climate change obligations, and more pressure from states and getting them to do that. We hope litigation and maybe all those cases in different jurisdictions around the world isn't necessary, but if it comes to that, I think that civil society and affected communities should be prepared to do so and implement that strategy.
I just wanted to say thanks to all of you for coming to be part of this conversation. I started by saying it was, in some ways, an awkward week. We're meant to celebrate 80 years of international institutions, and yet we've had a discussion about how it's a difficult moment for those institutions. On the other hand, the conversation we have had is in fulfillment of a spirit that says, working together, the world community will do better than being fragmented and seeing every opportunity as one to seize economic advantage against others. And I do think the lesson of cooperation is a powerful one. I believe that the human species has done better, not just over the last 80 years, but over the last 30,000 years when people collaborate and work together. And Camilla, you started us with a reference to the ICJ opinion about the obligation to cooperate. And I do think that is the right spirit to take away. And I'm glad to have all of you here in a conversation about what that cooperation could look like, should look like. And so while the celebration that was meant to be across town is not going so well, I feel like we brought that spirit here today, and I thank you for it. So please help thank our speakers.